Well, good morning. This is John Neerman, and it is my pleasure to call this meeting of the Texas Commission on Environmental Quality to order. Today is Wednesday, December 16th, 2020. Time is 9:30 a.m., and I'll begin with a roll call. Commissioner Lindley, are you there?
I'm here. I'll be on camera in 1 second. Good morning.
Great. Good morning. And Commissioner Janeka, I see you. Good morning.
Good morning.
So our commissioners are all present. And how about our general counsel? Ms. Smith, are you there?
I am. Good morning.
Good morning. And our public interest counsel?
Good morning. I'm here.
Good morning, Mr. McWhirter. I'd like to remind folks to keep their phones on mute when they're not speaking. I'd also like to remind anyone who is here only to listen that they can watch the meeting online. That link is available on the agenda notice. For each item where argument or discussion is allowed, we will inform speakers of their time limits. Registration has closed, but if you'd like to address the commission on a particular item, please email agenda@tceq.texas.gov with your name, affiliation, and the item you'd like to comment on, and we will do our best to accommodate the request. For those making presentations, please wait to begin your presentation until I or our general counsel have asked you to begin speaking, and please check to make sure that your line is unmuted before you speak. Colleagues, before we get going here, I'd like to pause and just recognize that this is our last meeting of 2020, and to say that it's been a challenging year is an understatement. The first vaccinations for COVID-19 are finally rolling out in Texas, and at the same time, the pandemic continues to rage with really terrible consequences. So I have a few admonitions as we wind up the year, and the first is I want to encourage anyone within earshot of this meeting to continue to protect themselves and their loved ones and their communities by practicing all of the familiar mitigation practices. And please just don't let up at this point. We can see the light at the end of the tunnel. I also want to say that for anyone who is feeling isolated or overly stressed, that's more than understandable given the year we've had. I encourage you, if you think you might fall in that category, to please seek support. In years past, I've sought counseling for difficult events in my life, and it's helped me. And if you're a TCEQ employee, I want you to know that you have the informal support of your colleagues, as well as professional support through our Employee Assistance Program. Our Deputy Executive Director, Ramiro Garcia, is spearheading our communications about this, and you can find resources in his estate emails. And if you like, I know he'd be happy to hear from you personally. And I want to thank Ramiro for taking that on. And my final admonition for the year is simply that you all be good to each other. As we enjoy the holidays and ready ourselves for the new year, I hope each of you can find some peace and share a little bit of that with those around you. And colleagues, with that, I'd like to give you an opportunity to offer any thoughts before we get started. Commissioner Lindley?
Very well said. I don't have anything to add on. I would just ditto everything you say, and I definitely thought we'd be doing this meeting in person, by now. But these are the cards we've been dealt with, and so looking forward to hopefully getting back to some normalcy, and that includes doing these agendas maybe in person in 2021. But thank you for those words, Chairman.
Thank you. I'm hopeful that we'll get to sit next to each other on the dais in 2021. Hopefully in the first half. We'll see. Commissioner Janeka, any thoughts to offer this morning?
I only to say thank you so much for those words, Chairman. I really could not agree more, and I think they're very well said, and especially echoing the sentiments to our employees and staff about the needs for mental health at this time of the year. Emotional weather, mental weather comes and goes, just as meteorological or polluted or epidemiological weather may change. So I really appreciate your remarks, and I just want to say it's been a really exceptionally challenging, but a really exceptionally fulfilling and satisfying year. I'm really proud of our agency and the new skills we've developed through the course of this year, some of the new tools we've discovered, and some efficiencies realized because of real challenges, real problems that we wrestled with and adapted to. So thank you so much, and I'm looking forward to coming back next year and racing into session along the rest of our colleagues.
Thank you, Commissioner Janetka. Colleagues, I appreciate your comments. I'd also like to thank everyone for being present at this meeting. And with that, Ms. Smith, I'll ask you to please call the first item.
Item number 1 is the consideration of the ALJ's proposal for decision and proposed order concerning the enforcement action against 2012 Weatherford Holdings, LLC. The order of presentation will be Executive Director, followed by Respondent, and then OPIC. In the Chief Clerk's November 24th, 2020 letter, parties were notified that they would each have 5 minutes of oral argument time in accordance with the Commission's standard practice, and the ED may save time for rebuttal as the ED bears the burden of proof.
And we'll hear first from the Executive Director. Good morning.
Good morning. For the record, my name is John Merkuliev, and I'm representing the Executive Director in this matter. Presenting with me is Thomas Clark with the Financial Administration Division. The Executive Director concurs with the substance of the ALJ's proposal for decision and recommends adoption of the proposed order with the inclusion of the Executive Director's exceptions, which are intended to clarify the order. Now, respondents stipulated as to the 13 violations that the Executive Director alleged and as to the penalty calculations that are associated with those 13 violations. The ALJ accepted the stipulations and incorporated them into his proposal for decision. Respondent's only challenge to the Executive Director's enforcement case against it was a financial inability to pay claim. Respondent first received notice of the Executive Director's allegations via exit interview forms signed on February 6 and 7, 2018. The notice of enforcement letter issued the same day that Respondent sold the water system, July 6, 2018. From there, Respondent paid its creditors of note at the time. It began distributing net proceeds of the sale to board members on July 24, 2018, and concluded those payments in December 2018. The Executive Director's preliminary report and petition was first filed in February 2019, and service was achieved on March 25, 2019. The ALJ found that Respondent violated TCEQ's financial review policy for administrative penalty inability to pay claims by failing to allocate any of the proceeds of the sale of the system to pay the administrative penalty in this case. The Executive Director filed exceptions to the proposed order for clarity, and the ALJ recommended incorporating those exceptions into his proposed order. Respondent filed no exceptions. We are here to answer any questions you may have. I would like to reserve the remainder of my time for rebuttal if necessary.
Thank you, Mr. Merkuliev. I have no questions. Colleagues, any questions? Commissioner Lindley?
No questions, thank you.
Commissioner Janetka?
None now, thanks.
Thank you. And Ms. Smith, just to confirm, do I understand correctly that there's no one here to speak on behalf of the respondent?
Let me confirm with Ms. Talk. I'm seeing him on the attendees, but I understood that he was not going to sign in.
Okay. And is that Mr. Nairn?
Yes.
Mr. Nairn, are you on the line?
Mr. Nairn, this would be your opportunity to say any words if you'd like to do so, although you're not required to. All right, hearing nothing, let's hear next from Public Interest Counsel. Mr. McWhirter?
Yes, I believe Eli Martinez is on the line. He represented our office in this matter.
Thank you. Good morning, Mr. Martinez.
Good morning, Chairman, Commissioners, General Counsel, and Executive Director. I'm Eli Martinez with the Office of Public Interest Counsel for the record. Our office participated in this hearing and ultimately agree with the proposal for decision as amended by Judge Rivas' response to exceptions. In this matter, the Executive Director and Respondent stipulated to facts showing the Respondent had committed the violations alleged in the EDPRP and that the administrative penalty of $22,830 had been correctly calculated. The only issue in dispute at the hearing was therefore the Respondent's ability to pay the administrative penalty. Mr. Nairn testified that when he received the ED's preliminary report and petition, he was in the process of completing the sale of the facility for $580,000 and further admitted the funds from the sale of the facility were distributed to the investors rather than toward paying the administrative penalty. However, under the TCEQ's financial review policy for administrative penalty inability to pay claims, the distribution of proceeds from the sale of the facility to investors was subordinate to the payment of the administrative penalty, and Mr. Nairn was expected to pay the assessed administrative penalties before he distributed sale proceeds. The respondent has failed to meet his burden to establish that a lesser penalty is justified and should be required to pay the full penalty. OPIC agrees with Judge Rivas that since Mr. Nairn no longer owns the facility and essentially has no cash flow, the Commission may want to consider a payment plan so that Mr. Nairn may pay the administrative penalty over 3 years. Thank you. I'm available for any questions.
Thank you, Mr. Martinez. I appreciate the analysis. I have none. Commissioner Lindley, any questions?
No questions, thank you.
Commissioner Janeka?
None for me. Thanks.
Thank you. Mr. Makuliev, would you like to offer anything in rebuttal?
No, thank you.
Not a whole lot to rebut. Thank you. Thank you for that. Well, colleagues, as we heard, the sole issue before the ALJ was whether the respondent, 2012 Weatherford Holdings, has the financial ability to pay the assessed penalty of $22,830 relating to public water system violations. The ALJ's opinion is clear that the respondent failed to meet its burden to show that a lesser penalty is justified under 30 Texas Administrative Code, Section 70.8. I don't see any ambiguity here. I would propose to amend Conclusion of Law 18 to make it clear that it's the respondent who bears the burden on this issue, and would also modify the order as recommended by the Executive Director's exceptions and agreed to in the ALJ's reply. So let me offer a motion to that effect, and then we'll take any discussion. Colleagues, I move that we adopt the ALJ's proposed order with the modifications recommended by the Executive Director's exceptions and agreed to by the ALJ's reply, and amend Conclusion of Law 18, which is the renumbered Conclusion of Law 17, to state, quote, respondent did not meet its burden to show that a lesser administrative penalty is justified under 30 Texas Administrative Code, Section 70.8, as demonstrated in finding of facts 5 through 9, end quote, and the end of my motion. So, Commissioner Lindley, let me ask if you have any thoughts or comments at this point.
I don't. That much to me.
Thank you. And Commissioner Janeka, I will entertain any comments or thoughts you have, or a second.
I think it's entirely appropriate to move forward today. I agree with you in the motion. I would second your motion.
Thank you. The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka, how do you vote?
Aye.
I also vote aye. The motion carries. Ms. Smith, please call the next item. Ms. Smith, you might check your microphone.
Sorry about that. I was reading along, but didn't quite get myself unmuted. Item number 2 is consideration of the proposal for decision and proposed order concerning the Executive Director's denial of the application by Donnell Baldwin for a water system operator license. The parties have been notified that the applicant, the Executive Director, and OPIC will each have 5 minutes of oral argument time. The applicant may speak first and may reserve a portion of time for rebuttal as he bears the burden of proof. He will be followed by the ED and then OPIC.
Thank you, Ms. Smith. And I understand that Mr. Baldwin does not plan on participating in the agenda, but let me just, out of an abundance of caution, see if he's on the line and would like to say anything. Mr. Baldwin, are you there? And if so, would you like to address the commission? Okay, hearing nothing, and it was our understanding that that would be the case, that he would not be presenting this morning. Let's hear next from the Executive Director.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Alicia Ramirez, and with me is Haya Zeman, PE, Deputy Director of the Occupational Licensing and Registration Division. We represent the Executive Director in this matter. The ED agrees with the Administrative Law Judge's proposal for decision and proposed order and recommends that the Commission adopt them with the change recommended by OPIC to change the word crime to license in conclusion of law number 6. We are available for any questions.
Thank you, Ms. Ramirez. I have none. Commissioner Lindley, any questions?
No questions, thank you.
Commissioner Janeka?
No, thanks.
Let's hear next from OPIC.
Good morning, Chairman, Commissioners, General Counsel, and the Executive Directors, Attorneys, and staff. I'm Amanda Pessanen for the Office of Public Interest Counsel. OPIC supports the Administrative Law Judge's proposal for decision and agrees with the ALJ's recommendation that the Commission deny Mr. Baldwin's application for a new public water system operator license. OPIC agrees with the ALJ that Mr. Baldwin's criminal offenses directly relate to the occupation of water system operator and that Mr. Baldwin did not satisfy his burden to prove his fitness for the license. OPIC has filed one exception recommending revision of the ALJ's conclusion of law number 6 to conform to the relevant statutory language. OPIC therefore recommends that the Commission adopt the ALJ's proposal for decision, sustain OPIC's exception, and issue the modified proposed order. Thank you, and I am available for any questions.
Thank you, Ms. Pessanen. I have none. Commissioner Lindley, any questions?
No questions, thank you.
Commissioner Janeka?
None, thanks.
Let me check one more time to see if Mr. Baldwin is on the line and would like to address the Commission. This would be his rebuttal opportunity. Okay, hearing none, which is what we anticipated. Colleagues, let me offer some of my thoughts. I struggled with this one, honestly. I think this item raises some very difficult issues about what is best for the community as well as for Mr. Baldwin. And while the statute assigns this agency the responsibility of determining who should receive an occupational license for water system operation and who, by virtue of their criminal history, should not, I'm not sure that this agency has the best expertise to make that decision. That said, I believe the decision reached by the Executive Director and upheld in this PFD to deny Mr. Baldwin's application is consistent with the relevant law, and it's reasonable. Denial may be the best course for this agency. I still, though, have some reservations about whether it is truly the best resolution. As the father of a child around the age of Mr. Baldwin's victims, I am clear-eyed and frankly sickened by the gravity of his crimes 20 years ago. At the same time, our criminal justice system has addressed the penalty and Mr. Baldwin has paid that debt. And I also believe that there's value to our community if Mr. Baldwin can achieve more of his potential. For example, we need more water system operators. So again, I struggle with the question of how we balance all of this in addressing the risk to public safety. And so I'm going to, for the time being, punt on this one. And without quite coming to my own conclusion yet, I'd like to gather your thoughts. And Commissioner Lindley, let me begin with you.
Sure. No, I'll say it again. I'm dittoing everything you said. I did struggle with this one as well. Just didn't sit well with me for a lot of reasons, and you spoke to those. Ultimately, where I came down on it, though, is in support of adopting the ALJ's PFD. And truly, for me, a lot of it came down to, like you said, I do think the Executive Director proved their case, and it's a reasonable conclusion. But I really, I might have been persuaded more, maybe that's the way to say it, if there had been some sort of proof that he was fit to do the job. I believe Amanda said that as well. I just think the company he works for maybe could have provided some sort of letter of support. I don't know. And it's hard to say that whether that would have changed my mind because it didn't happen. But it was up to Mr. Baldwin to prove that he, it was his burden of proof, I guess you say it that way, that he's fit to do the job. And he participated in the hearing, and he didn't do that. And so ultimately I landed on, I'm landing on being supportive of adopting the ALJ's proposed order. But this is definitely a new one, and there were a lot of things that made me question the role of the agency in this situation. But that's how I came down, and I'll stop there.
Thank you, Commissioner Lindley. Commissioner Janeka?
Thank you both. I really do appreciate both of your comments on this, and I think I share your concerns on many of the factors that each of you mentioned. I consider this a live policy space to some degree in terms of we're implementing legislation right now, implementing rulemaking that would, at the direction of the legislature, provide a little more flexibility and a little more rights to individuals in these circumstances where they're wanting to pursue a professional licensure, occupational licensure, and have some criminal record that they're wanting to assert rights and understand where the agency decisions are. So I think the legislature is attuned to this one as well. In my view, in terms of the record for this matter, I think that perhaps the ALJ shared the view that I'm hearing, reading between the lines from each of y'all, and that was this is a very difficult burden for a regulatory agency to overcome, and you really need to build that argument and give us more facts and more of a defense in favor of the decision you want from the outcome. And it sounds like Mr. Baldwin, unfortunately, just did not avail himself to providing those records and documents to come before the record. It looks like, I agree with you, Chairman, the resolution of that past criminal history was resolved satisfactorily from our state's criminal justice system. And so that final lift, that final piece didn't materialize where Mr. Baldwin was able to go get some letter of recommendation from that criminal justice system as our rules require, specify, and then, or from another colleague, some sort of a character witness that may have changed the outcome of this case. I'm not sure that I see enough facts in the ALJ's decision to see any basis to alter it. But I certainly share your mindset as you approach this matter.
Thank you, Commissioner Janeka. Commissioner Lindley, I really do appreciate your analysis. All of what you said was ringing true. Same goes for your analysis, Commissioner Janeka. There is still a potential path for Mr. Baldwin to get this license, and that's, I think, the most direct path if we deny this one is reapplying, presenting the same information, except adding to it some letter of support from a member of the community who can speak to his fitness for this position, his rehabilitation, whether a prosecutor or an employer or community member in good standing, whoever that may be, which if I were in Mr. Baldwin's shoes, I would read that as a significant burden, including a new application fee of $180, whatever it is, a significant burden without any guaranteed outcome. So, I'm a little bit, I feel like our agency perhaps could do better, or our laws could do better to achieve a better outcome for the community. But I think in the end, colleagues, I come down where you do, that we have to err on the side of caution, recognizing that it very well is an error here. I think I'm in agreement with the two of you that we should move forward with this proposal for decision. That it is that there's nothing inappropriate about it. That it is appropriate in terms of the authorities that we have to go by, and the record in the case. So with that, I'll entertain any additional thoughts or a motion. Commissioner Lindley?
I can do a motion, and I will just say if Judge DuBose, I believe that was the judge, David DuBose is listening in, I think the judge had a hard case and did a good job. So with what was before him. But I will make a motion, and I would move that we adopt ALJ proposed order, but modify conclusion of law number 6 to replace the word crime to license as recommended by OPIC's exceptions and agreed with in the ALJ's reply.
Second the motion.
Motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
Aye.
I also vote aye. Motion carries. Ms. Smith, please call the next item.
Item number 3 is the application by the City of Buda and the GBRA to renew TPDES permit number WQ0011060001. The parties have been notified that the Commission will not take oral argument but may ask questions. Those who have signed in will be noted for the record.
Thank you. Colleagues, Ms. Byrd requests a hearing on this application. It's for a no increase renewal. However, because the application meets all of the requirements of Texas Water Code Section 26.028D, there is no right to a contested case hearing. So I'm going to move that we find that there is no right to a hearing on this application pursuant to Texas Water Code Section 26.028D and 30 Texas Administrative Code Section 55.201I5, that we deny the hearing request, that we issue the renewal of TPDES permit number WQ0011060001 to the City of Buda and GBRA as recommended by the Executive Director, and finally that we adopt the Executive Director's response to comments. And I'll entertain any thoughts or a motion, Commissioner Lindley. I'm sorry, or a second.
As I say, that was a great motion. I will second that motion.
Commissioner Janeka?
Oh, the thoughts from me, I'm comfortable moving forward. I'm in full agreement with your analysis on it.
Thank you. The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
Aye.
I also vote aye. The motion carries. Ms. Smith, please call the next item.
Item number 4 is the consideration of the application by RR417 LLC for water right permit number 13631. The parties have been notified that the Commission will not take oral argument but may ask questions. Those who have signed in will be noted for the record.
Thank you. I'd like to begin by offering Mr. Hombacher our condolences for the loss of his wife, Dr. Dryden, who passed away in October. Mr. Hombacher, together with his wife, were among numerous individuals to request a hearing on this item, and Dr. Dryden was the only individual who did not later withdraw her request. And while it seems likely that she too would have withdrawn, we are not free to make that presumption. However, in analyzing her request, I've concluded that she did not raise a personal justiciable issue and therefore is not entitled to a hearing. And accordingly, I would deny the request. And that's my analysis. Commissioner Lindley, how did you come out on this?
I'm in agreement with your analysis.
Commissioner Janeka, you want to offer your thoughts or a motion or both?
No, I think you captured it succinctly. It was an interesting set of particular facts on this matter, and I appreciate your making that statement of condolences to the bereaved and his departed wife. I think that's absolutely appropriate. But I arrived at the same conclusion, and I would make the motion that we deny all hearing requests and issue water use permit number 13631 to RR417 LLC.
I second.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
Aye.
I also vote aye. The motion carries. Ms. Smith, please call the next item.
Item number 5 is consideration for approval to invoke Rider 11, the reallocation of revenue and balances for certain accounts, to provide funding to the Rio Grande Compact Commission for the continuation of Texas's lawsuit against New Mexico for the equitable distribution of water under the 1938 Compact. The Executive Director's staff is here to present the item.
Thank you. Good morning.
Good morning, Chairman. Can you hear me?
I can.
Okay, good. Thank you. Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Elizabeth Cifuentes-Koch, Deputy Director of the Budget and Planning Division. With me is the Rio Grande Compact Commissioner, Pat Gordon. We are presenting the Executive Director's recommendation to invoke Rider 11, reallocation of the revenue and balances for certain accounts. This is on behalf of the Rio Grande Compact Commission to support the continuation of Texas's lawsuit against New Mexico for the equitable distribution of water under the 1938 Compact. The litigation is in the final stages of the case, with trial expected to begin around July or August of 2021. We estimate $3 million is needed to carry the case through April. With your approval, the agency will reallocate funds from several accounts in fiscal year 2020-2021 to the Rio Grande River Compact Strategy and the Water Assessment and Planning Strategy. Transfers will occur from the Air Quality Assessment and Planning Strategy, from the Clean Air account and the Operating Permit Fees account. Up to $500,000 each of these accounts to be transferred to those strategies. Other accounts include Storage Tank Admin and Cleanup Strategy for the Petroleum Storage Tank, up to $1 million. Hazardous Materials Cleanup Strategy for the Hazardous and Solid Waste Remediation account, up to $500,000. A supplemental appropriation will be requested to restore the funds to the impacted programs and to support the litigation for the remainder of the fiscal year. We estimate the supplemental appropriation request to be around $5 million. We request your approval to invoke Rider 11 in support of the litigation between Texas and New Mexico. If approved, notification will be provided to the Governor, the Comptroller of Public Accounts, and the Legislative Budget Board of our intent to reallocate funds as required by the rider. This concludes our presentation, and we appreciate your time and are available for questions. Thank you.
Thank you. I have none. Commissioner Lindley?
I don't think so. I was going to ask to clarify one or two things, but you stated it all. But just to restate one thing you said that I think is very important for anyone that might be tuning in is that the agency is going to be seeking help, I guess, in the supplemental bill to get reimbursed for these expenses. And that is, I believe, Elizabeth, you said it's $5 million will be the ask in the supplemental bill. Is that correct?
Right, that's our current estimate. We do want to true up that number before we report it to the Legislative Budget Board, but right now we're estimating around $5 million.
Okay. Yeah, I mean, it is painful to make this vote just because it's a lot of money that the agency is coming up with, but the lawsuit's very important, and I understand the importance of continuing to push strong, and Commissioner Gordon, appreciate, your work on this. I know it's, and Chairman Nierman has attended many of these hearings and such, but this has been years in the making, and we'll be very excited once this case is behind us, and hopefully we're successful.
Thank you, Commissioner Lindley. I appreciate your observations. Commissioner Janeka, any questions for ED staff?
Thank you. No particular questions for ED staff at this time. I appreciate some of the concerns Commissioner Lindley raised on this. I'll hold my peace and may weigh in a bit later if we discuss further. Thanks.
Thank you. And I think we hear next from Mr. McWhirter.
Good morning. OPIC supports the ED's request. We have no objection to the proposed reallocation.
Thank you, Mr. McWhirter. Well, colleagues, as you're well aware, the Rio Grande litigation is really critical for Texas in defending our interests under the Interstate Compact, and that includes both receiving compensation for water that's been unlawfully withheld from Texas and also safeguarding future deliveries that are owed to Texas. And I've personally been disappointed to see New Mexico's evolving litigation strategy that unnecessarily drives up the cost of litigation for Texans as well as for New Mexicans. But that, unfortunately, is their prerogative. And, of course, Texas will continue to meet the demands of this case. The request at issue here is going to help cover the expenses that have become necessary as a result of New Mexico's strategy. I've been briefed on the request, and among the available options, I think this is the best choice for structuring the funding given the current circumstances. So I would vote to approve the request and would like to hear your thoughts, beginning with you, Commissioner Lindley.
I'm in agreement. I'm going to vote to approve it. I guess one thing since we're talking about this for a quick second, just maybe have Elizabeth comment on this real quick, but you know, what you mentioned was the supplemental requests we're going to be making during the session, but we are also going to be asking for more money to continue the lawsuit as well. Will you just state kind of what that plan is or that amount? I have my LAR documents in front of me, but I don't want to shuffle a bunch of papers. Oh, so as does, yeah.
Yes, I can let you know. So for the 22-23 budget request, we included $5.1 million to continue the litigation.
Okay, that's what I was thinking. Thank you. I don't have any other comments or thoughts. I'm in agreement on we need to approve this today.
Thank you. Commissioner Janeka.
I'm likewise in agreement. This was a very thorny issue. The legislature has assigned responsibility to our agency to support and help carry over the finish line through the coordination of the Office of Attorney General and the outside legal counsel. And I think that it's a critically important effort. This week is not the week to diminish or not fully appreciate the risks and stakes of interstate disputes over water and water rights and allocations. Decision this week with the Pecos River that did not come out in Texas's favor from the Supreme Court. And I think that that helps, in my view, really underscore how important this is not to let off the gas as we approach the 0 hour of making our case. And I appreciate your efforts, Chairman Neerman, to follow this issue and to help support our state's arguments on it. But I'm comfortable moving forward today as well. Thanks.
Thank you, Commissioner Janeka. Colleagues, if there's nothing else, I think I'm ready to entertain a motion.
I will move that we approve the Executive Director's request to invoke Rider 11, reallocation of revenue imbalances for certain accounts to provide funding to the Rio Grande Compact Commission for the continuation of Texas's lawsuit against New Mexico for equitable distribution of water under the 1938 Compact.
I second.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
Aye.
I also vote aye. The motion carries. Ms. Smith, please call the next item.
Item number 6 is the consideration of gifts and donations of $500 or more in value given to the TCEQ, submitted for approval in accordance with Chapter 575 of the Texas Government Code concerning acceptance of gifts and donations by certain state agencies. The Executive Director's staff is here to present the item.
Good morning.
Good morning, Mr. Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Yan Tran of the General Law Division, representing the Executive Director. Before you are the gifts and donations received by the agency in the past 90 days. In accordance with Chapter 575 of the Government Code, the Executive Director has accepted these gifts and respectfully requests your acknowledgement of these gifts. As always, I'm available to answer any questions you may have concerning these items.
Thank you, Ms. Tran. I have none. Commissioner Lindley, any questions?
No questions. Thank you.
Commissioner Janeka?
None. Thanks.
Thank you. Mr. McWhorter, what are your thoughts?
OPIC recommends approval of the resolution acknowledging gifts and donations as presented by the Executive Director.
Thank you. I agree. These are relatively small gifts and entirely appropriate in my view, so I recommend that we approve issuance of the resolution of acknowledgement. Commissioner Lindley, I'll entertain any thoughts or even a motion.
I'm in agreement, and I would move that we approve issuance of the resolution acknowledging the Executive Director's acceptance of the gifts and donations contained in the TCEQ Interoffice Memorandum to the Commissioners dated November 24th, 2020, docket number 2020-1436-MIS.
I second the motion.
Thank you. The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
Aye.
I also vote aye. The motion carries. Ms. Smith, please call the next item.
That takes us to the enforcement docket, items 7 through 26. The Executive Director's staff is here to present these matters. And before you begin speaking, if you could state your name for the record.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Melissa Cordell of the Enforcement Division, and with me today is Brian Sinclair, also of the Enforcement Division, and Charmaine Backens of the Litigation Division representing the Executive Director. Pending before you are items 7 through 26. The total assessed administrative penalties are $388,196, with $51,160 deferred, $34,470 applied toward supplemental environmental projects, and $302,566 to the general revenue. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you, Ms. Cordell. I have none. Commissioner Lindley?
No questions. Thank you, Melissa.
Commissioner Janeka?
None. Thanks so much.
Thank you. And Ms. Smith, am I correct that there's no one signed in to speak on these items?
That's correct.
All right. We'll hear next from OPIC.
OPIC reviewed these items, and we recommend approval of the orders as presented by the ED.
Thank you, Mr. McWhorter. I agree. I've reviewed these items. I think it's appropriate to approve them. Commissioner Lindley, any additional thoughts?
No, I'm in agreement.
Commissioner Janeka?
Likewise, agreement across the board. I will make the motion that we adopt items 7 through 26 as recommended today by the Executive Director.
I second.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
Aye.
I also vote aye. The motion carries. Ms. Smith, please call the next item.
Item number 27 is the consideration of the monthly enforcement report, and the Executive Director's staff is here to present that matter.
Good morning again, Ms. Cordell.
Good morning. Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. My name is Melissa Cordell of the Enforcement Division, and with me is Brian Sinclair of the Enforcement Division and Charmaine Backens of the Litigation Division. We are here to present the monthly enforcement report for fiscal year 2021 through October. There were 186 effective administrative orders issued, and of those, 27 contained supplemental environmental projects. These orders assessed a total of $2,089,421 in penalties, with a payable amount of $1,314,678. $425,482 are to be paid towards supplemental environmental projects. 2,438 notices of violation have been issued through either our field offices or review of self-reported data in our central office, and 216 enforcement action referrals have been received. There are 1,482 pending administrative orders with 191 cases that are on the backlog. 207 cases are pending at the Attorney General's Office for representation in district court, and 2 judgments have been issued. 2,067 cases are being tracked for compliance. We've included for review a summary of OCE investigative activities for fiscal years 2019, 2020, and 2021. We are available to answer any questions you may have.
Thank you. I have none. Commissioner Lindley, any questions?
No questions.
Commissioner Janeka?
Only want to provide the opportunity if ED staff would like to comment on it. The number of backlog orders, just looking at that summary of data from FY 19, 20, 21, I think that it's merely one of the numbers on the dashboard to watch, but I'm curious if there's any thought or particular plans at this time to adjust our posture, given that there is a higher number we're inheriting from the end of fiscal year 20.
Yes, Commissioner, this is Brian Sinclair. We are still working to refine and improve our workflow processes in the telework environment to address and reduce the backlog and to ensure cases progress in a timely manner. We're working with our partners in litigation division so that the ones over there and the ones in the enforcement division are addressed, and it's not certainly not entirely due to the telework environment, but we are addressing the issues, and hopefully we will make good progress on this in the months to come.
Thank you, Mr. Sinclair. I think that that certainly gives me a better sense of where ED staff thinking is on this topic. And I appreciate y'all's efforts to juggle all the pressing needs, and particularly as we head into the legislative session. I know that puts an additional strain on your staff as you're trying to assist and respond to legislative inquiries about prospective changes to the law. So I just wanted to have the ask before we headed into the end of the year, but I appreciate y'all's work. Thank you.
Thank you, Commissioner Chineka and Mr. Sinclair. I think we're ready to hear from our Public Interest Counsel, Mr. McWhirter.
I don't have any questions. I appreciate the report and all the work it represents.
Likewise, I want to thank the team for putting this together, and just as Mr. McWhirter said, all the work that it reflects. No action is necessary on this item, so Ms. Smith, I'll ask you to please call item 28.
Item number 28 is the consideration of a petition for rulemaking filed by the Texas On-Site Wastewater Association, Incorporated, to amend 30 Texas Administrative Code, Chapters 30 and 285, concerning on-site sewage disposal systems and the licensing of on-site sewage disposal system professionals. Texas On-Site Water Association is represented by Randy Shillette, its executive director. They're the moving party, and they should present the matter, followed by other interested persons, the executive director, and then OPIC. The Office of General Counsel recommends limiting the speakers to 5 minutes for their presentation.
Thank you, Ms. Smith. And Mr. Shillette, good morning. When you're ready, just please state your name and any affiliation, and the floor is yours.
Yes, sir. Good morning, Chairman Neerman. Randy Shillette, Texas On-Site Wastewater Association. Our association spent the last couple of years reviewing the rules as well as presenting them to our members and TCQ staff. We appreciate this opportunity to bring these petitions before the commissioners and move forward with updating our rules and advancing them to protect public health and environment.
Wonderful. Thank you, Mr. Shillette. And Ms. Smith, let me ask if there's anybody signed in asking to speak on this item.
We have a number of people signed in who asked not to speak, and their names will be reflected in the record. And then we have 3 people who are signed in to speak: Mr. Brian Wakefield, Mr. Mike Braden, and Mr. Ron and Suchecki.
Okay, well, let's begin with Mr. Wakefield. Mr. Wakefield, I'll ask you to go ahead and state your name and any affiliation for the record, and then the floor is yours.
Chairman, this is Megan. Mr. Wakefield is trying to get on the phone right now. I just got off the phone with him. If you want to move on to a different one, sorry.
Sure, we'll come back to Mr. Wakefield. Is Mr. Braden on the phone?
I am. Can you hear me?
I can, loud and clear. Good morning. Good morning, sir. I'll ask you to go ahead and state your name and any affiliation for the record, and then go ahead and offer your comments.
My name is Michael Braden, and I'm a TALA board member. And I just wanted to get on and say that I fully support everything that Randy's putting forward.
Wonderful. Thank you, Mr. Braden. I appreciate that. And Ms. Smith,
thank you.
Who was the third commenter who signed in wishing to speak?
Mr. Suchecki. I'm sorry if I'm
Suchecki?
mispronouncing that name.
Mr. Suchecki, apologies if we're jumbling your name, but if you'd like to state your name correctly for the record and any affiliation, I'll turn it over to you to offer your comments. And you might check to see if you're on mute. Because we are unable to hear you.
Chairman Neerman, can you hear me, Randy?
I can, Randy. Thank you.
Ron just sent me a text. He apologized, but he's boarding an airplane. He was afraid this might happen, so he's unable to respond. But it's basically in support of I'm reading his text, so he is in support of the petitions.
Okay, thank you. I appreciate that. And why don't we return to Mr. Wakefield and see if he's been able to dial in. Mr. Wakefield, are you there?
He has not yet. He was under the impression it would be a little bit later, so he's still just trying to get in.
I see.
Is there anyone else?
All right,
Yeah.
well.
When we jumped from item number 7 to 28, I think it caught a few of them off guard. So.
Oh, I see. Okay. Well, I apologize for that, and that Mr. Wakefield is unable to offer his comments this morning. And I appreciate the comments that we did receive. Why don't we move on now to the Executive Director?
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, my name is Shannon Frazier, work leader of the On-Site Sewage Facility Program with the Program Support Environmental Assistance Division. With me is Ms. Christy Mills-Jarac, Deputy Director of the Program Support Environmental Assistance Division, Ms. Haya Zeman, Deputy Director of the Occupational Licensing and Registration Division, and Mr. Cole Malley with the Environmental Law Division. On November 12, 2020, the TCEQ received a petition for rulemaking from the Texas On-Site Wastewater Association requesting revisions and additions to 30 Texas Administrative Code Chapter 30, Occupational Licenses and Registration, and Chapter 285, On-Site Sewage Facility Rules Compilation. The petition proposes changes to the regulation to create more consistency with the industry terminology and standards, including adding language to more easily identify responsible parties, including definitions of TCEQ licensed individuals, and creating a new licensing registration program for sludge pumpers. The Executive Director has concluded that additional stakeholder input is needed to determine which of the petitioner's requested rule revisions are appropriate. Therefore, the Executive Director recommends that the Commission grant the petition and direct the Executive Director to initiate rulemaking for Chapter 30 and Chapter 285, and additional stakeholder input indicates that rulemaking is needed for these rules. Thank you. We are available to answer any questions.
Thank you for the presentation. I have none. Commissioner Lindley, any questions?
No questions, thank you.
Commissioner Janeka?
Not at this time, thanks.
Thank you. And Mr. McWhirter, what are your thoughts?
OPIC recommends the Commission grant the petition for rulemaking filed by the Texas On-Site Wastewater Association and seek further stakeholder input as recommended by the Executive Director.
Thank you. I agree with that. I do want to begin by thanking Mr. Shillette and the Texas On-Site Wastewater Association for developing these ideas to improve our regulation of on-site sewage disposal. I think it's appropriate to initiate rulemaking and engage all of the stakeholders on these issues, but with the caveat that this action does not mean that the Commission will adopt any particular rule. So with that in mind, I'd be ready to ask the Executive Director to initiate rulemaking. Commissioner Lindley, how do you see it?
See it the same way.
Commissioner Janeka?
Likewise, I'm in agreement. I just wanted to say how I was really struck by the breadth and level of detail in this particular petition. I think we've seen some that are more conceptual. This petition struck me as being very thoughtful in looking through many chapters of our rules where their association or their operators and members may have interfaced with our agency. And I just want to say I'm really appreciative of that level of effort from the public in trying to understand and provide feedback to us about our rules. It's really valuable and helpful generally. I hope that in directing ED, we find ED to initiate rulemaking as I sounds like we're ready to do today. I hope that those suggestions are all as helpful to staff as I realize that there's always nuance, and so it may appear to be very simple to change our rules from the outside. I hope that this helps initiate a good, lively conversation with our staff so that they can help y'all understand where these rule changes may be appropriate or there may be an alternate pathway. But I'm just very grateful for the effort that y'all put into it. So thank you.
Thank you, Commissioner Janeka. I appreciate and agree with those observations. And at this point, I think I'm ready to entertain a motion.
I'll make the motion that we direct the Executive Director to initiate rulemaking to examine the issues raised in the petition for rulemaking filed by Texas On-Site Wastewater Association Incorporated concerning amendments to 30 Texas Administrative Code Chapters 30 and 285.
I second.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
Aye.
I also vote aye. The motion carries. Ms. Smith, please call the next item.
Item number 29 is consideration for publication of and hearing on amendments to the repeal of certain sections within 30 Texas Administrative Code, Chapter 116, control of air pollution by permits for new construction or modification, and corresponding revisions to the state implementation plan. The Executive Director's staff is here to present the item.
Good morning.
Good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. For the record, I'm Michael Wilhoit with the Air Permits Division on behalf of the Executive Director. Also online with me are Samuel Short, Deputy Director of the Air Permits Division, and Terry Salem of the Environmental Law Division. The proposed rulemaking would revise Chapter 116, Control of Air Pollution by Permits for new construction or modification, to align Commission rules relating to the applicability of prevention of significant deterioration and non-attainment new source review requirements with recent guidance and rules for project emissions accounting issued by the United States Environmental Protection Agency. The proposed rulemaking will also repeal obsolete rules associated with the permitting of grandfathered facilities. If adopted, selected revisions to Chapter 116 will be submitted to the EPA as a revision to the state implementation plan. A public hearing will be offered on this proposal on January 26, 2021. Staff respectfully recommends approval for the publication of and hearing on the proposed revisions to Chapter 116. Staff also respectfully requests permission to make non-substantive revisions if necessary to comply with Texas Register requirements. Thank you. We are available to answer any questions.
Thank you, Mr. Wilhoit. I have none. Commissioner Lindley?
No questions. Thank you.
Thank you. Commissioner Janeka?
Likewise, none. Thanks.
Thank you. Ms. Smith, has anyone signed in to speak on this item?
No one is signed in on this one.
Thank you. And Mr. McWhorter, what are your thoughts?
OPIC recommends approval for publication of the proposed changes to the Chapter 116 rules and the corresponding revisions to the state implementation plan as presented by the Executive Director.
Thank you, Mr. McWhorter. Colleagues, as we heard, this rulemaking would remove obsolete provisions and also bring our rule in line with current EPA guidance. I think it's right for publication, and we're ready to take public comment on it. Commissioner Lindley, what are your thoughts?
I'm in agreement, and I can offer a motion.
Great.
If we're ready. I would move that we approve the publication of and hearing on certain amendments to 30 TAC Chapter 116, control of air pollution by permits for new construction or modification, and repeal 30 TAC Chapter 116, Subchapter H, permits for grandfather facilities and related sections, and corresponding revisions to the state implementation plan as recommended by the Executive Director.
I second the motion.
Motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
Aye.
I also vote aye. The motion carries. Ms. Smith, please call the next item.
Item number 30 is the consideration of the adoption of amended Section 17.14 and 17.17 of 30 Texas Administrative Code, Chapter 17, Tax Relief for Property Used for Environmental Protection, and Sections 18.25 and 18.26 and 18.30 of 30 Texas Administrative Code, Chapter 18, regarding rollback relief for pollution control requirements. The Executive Director's staff is here to present this item.
Good morning.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Elizabeth Sartain with the Air Quality Division. With me is Don Redmond with the Environmental Law Division. For your consideration today are the Executive Director's revisions to 30 Texas Administrative Code Chapters 17 and 18, Item 30. The revisions would implement Senate Bill 2, Section 44 from the 86th Texas Legislature 2019 regular session regarding the title of the program in Chapter 18. Additionally, the revisions revised Chapters 17 and 18 to add heat recovery steam generators and 11 other pollution control property items to both Tier 1 tables, as well as accommodate the addition of heat recovery steam generators. Finally, the rulemaking would fulfill the Commission's statutory and regulatory requirements to review and update as necessary the Chapters 17 and 18 expedited review lists and Tier 1 tables. Staff respectfully requests adoption of the Chapters 17 and 18 rulemaking. Staff also respectfully requests permission to make non-substantive revisions to comply with Texas Register requirements. We are available to answer any questions.
Thank you, Ms. Sartain. Appreciate that. Commissioner, I have no questions. Commissioner Lindley, any questions?
No questions as well. Appreciate all the work that's gone in on this.
And there's been a lot of it. Commissioner Janeka, any questions?
Yeah, well said. Way to allude to, no questions at this time. Thank you, and echo that sentiment heartily.
Thank you. Ms. Smith, has anyone signed in to speak on this item?
No one is registered.
Thank you. Mr. McWhirter, what do you think?
OPIC recommends adoption of the amendments to Chapters 17 and 18 to revise the Tier 1 tables consistent with the recommendation of the Advisory Committee and the Executive Director.
Thank you. And I also want to thank the Tax Relief for Pollution Control Property Advisory Committee for all of their good work on the implementation of the Proposition 2 program, including the difficult question of how to treat heat recovery steam generators under the rules. The Commission is required to determine the pollution benefit of these generators as compared to the production benefit. There's really no way around that. And this adoption would accept the committee's recommendation. And no matter what we do, it's going to have tax revenue implications. And in my view, the comments objecting to this rule reflect philosophical differences, and they also reflect a minority position. And colleagues, candidly, where I am with this is I'm truly agnostic at this point about how much tax is or is not paid on heat recovery steam generators. My only requirements is that whatever we do be consistent with the legislative intent and that it's going to be likely to survive judicial review. And I think the current proposal satisfies those requirements about as well as any solution will. And so I'm ready to move forward with adoption. Commissioner Lindley, how do you see it?
I agree. This is a tough issue for this advisory committee to try and tackle, and executive director staff. So I think they came down as best they could, and I'm comfortable. I think what's before us is reasonable, so I'm comfortable adopting what's before us today.
Thank you. Commissioner Janeka?
I have no way to improve on the statements each of y'all just made, so I'll just say I agree, and I'll make a motion that we adopt the amended sections of 30 Texas Administrative Code, Chapter 17 and 18, as recommended by the Executive Director.
A second.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
Aye.
I also vote aye. The motion carries. Ms. Smith, please call the next item.
Item 31 is the consideration of the adoption of amended sections 39.403, 50.113, 55.101, 55.201, 331.2, 331.5, 331.7, 331.47, 331.64, and 331.121, and repealed sections 331.17 and 331.18 of 30 Texas Administrative Code. The Executive Director's staff is here to present this item.
Good morning.
Hi, good morning, Chairman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I'm Tamara Young with the Radioactive Materials Division. With me is John Bates and Carol Dye with the Radioactive Materials Division and Don Edmond with the Environmental Law Division. This rulemaking amends Chapters 39, 50, 55, and 331 to streamline the regulation for pre-injection units associated with injection models by removing redundant requirements for registering or permitting pre-injection units. The proposed rules were published for comment in the August 14, 2020 issue of the Texas Register. The comment period closed on September 15, 2020. No comments were received. No changes were made since proposal. Staff requests approval for the adoption of amendments to Chapters 39, 50, 55, and 331, and permission to make non-substantive corrections to the adoption package if necessary to comply with Texas Register format and style requirements. Thank you for your consideration. We are available to answer any questions.
Thank you, Ms. Young. I have none. Commissioner Lindley?
No questions. Thank you.
Thank you. Commissioner Janeka, any questions?
No questions. Only to echo the sentiment at this point in the rulemaking. I'm pleased to see we didn't have any controversy or concerns from the public. But as with the personal experience in my past of getting to see technical staff having to twist up a little bit with Environmental Protection Agency and the Nuclear Regulatory Commission's respective understandings of this space, that Texas had managed to have a little duplication of programmatic oversight. I'm really pleased to see this change. So thank y'all so much.
Thank you, Commissioner Janeka. Ms. Smith, has anyone signed in to speak on this item?
No.
Thank you. And Mr. McWhorter, what are your thoughts?
OPIC recommends adoption of the amendment and repeal of the rules cited in chapters 39, 50, 55, and 331 to remove requirements to permit or register pre-injection units associated with non-hazardous, non-commercial Class 1 and Class 5 wells. As the ED has explained in the materials, the changes would be consistent with how these units are managed under other regulatory settings and by EPA, and will result in a streamlined application process. OPIC agrees with the ED and recommends adoption.
Thank you, Mr. McWhorter. Colleagues, as we heard, these amendments both streamline the pre-injection unit regulations and resolve inconsistencies with EPA's underground injection control program. They appear to me to be sensible as well as non-controversial. As Commissioner Janeka pointed out, there were no comments on this proposal. Or at least I think his point was that it was non-controversial. So I'm certainly ready to move forward with adoption. Commissioner Lindley, how do you see it?
I agree, and I too am ready to move forward with adoption.
Commissioner Janeka, anything to add?
Only to, if it won't steal the thunder, I'll make that motion. I move that we adopt amended sections of 30 Texas Administrative Code chapters 39, 50, 55, and 331, and repealed sections 331.17 and 331.18, as recommended by the Executive Director.
I second.
The motion has been made and seconded. Commissioner Lindley, how do you vote?
Aye.
Commissioner Janeka?
Aye.
I also vote aye. The motion carries. Ms. Smith, please call the next item.
Item number 32 is the public comment session. No one has signed in to address the commission, but we will unmute the webinar for a moment and give those on the line a chance to let us know if they would like to address.
I sent him
Would anyone like to address the commission during the public comment section? We're on item 32.
At his earliest.
I'm concerned that we're listening in on somebody's private conversation sidebar. I'm not hearing anybody speaking up to comment, so why don't we go ahead and mute the line before somebody gives away confidential business information or some other horror, and call the next items, Ms. Smith.
Items 33 through 36 are for executive session, and the commission will meet in executive session via video conference this morning as permitted by the Open Meetings Act, including Texas Government Code sections 551.071 and 551.074 to take up and consider matters pursuant to items numbers 33 through 36 as posted and noticed.
Thank you. And colleagues, why don't we shoot to meet there at 10:45? Does that work for you? Gives us about 6 minutes. Okay. And assuming we take no action in executive session, we'll have Ms. Smith return to gavel us out. And with that, the time is 10:39, and we stand in recess.
The Commission met via video conference for closed session from 10:55 a.m. until 11:36 a.m. on item numbers 34, 35, and 36 as posted in notice pursuant to Texas Government Code Section 551.074. No action was taken. This agenda stands adjourned. The time is 11:38.